Welcome, everyone. I'm Angelo Robles to Angelo Robles' Effective Family Office podcast, where I look to distill the best practices and best ideas of the world's most successful families and their family offices. I hope to provide thought-provoking opinions and feature amazing thought leaders to our listeners of the podcast with an eye towards the future of the family office. Today's topic is everything you wanted to know about private trust companies. Our special guest is the definitive authority on the subject. I've known him for a long time, and it's a pleasure technically to have him as a return guest to the podcast, but that first one goes back many, many years ago. And that would be Al W. King III, JD LLM, AEP, distinguished TEPs, the co-founder, co-chairman, and co-chief executive officer of the South Dakota Trust Company. As noted, Al is the co-chairman, co-chief executive officer of the South Dakota Trust Company and SDTC related companies with offices in South Dakota, New York, Wyoming, Nevada, and near my backyard, Westport, Connecticut, where Mr. King is based. South Dakota Trust Company is a national trust boutique serving wealthy families in 54 countries around the world, and they currently have more than $78 billion in assets under administration. Previously, Mr. King was managing director and national director of estate planning for Citigroup, and also the co-founder and vice chairman of Citicorp Trust South Dakota. Al has even a longer bio, and of course it's distinguished, but for the purposes of video and audio, we know we have to get right to the action, so I think it's about time to begin. Al, welcome to the show.
Thank you very much. Good to be here, Angelo.
It's a pleasure, and such an important topic for families of wealth and their family offices, especially now more than ever for a variety of reasons. Why don't we start with really the most foundational of questions for those who might be a little unclear. Very simply, Al, what is a private trust company?
Yeah, a private trust company is an entity that's cleared by usually some state division of banking to serve as trustee. As you know, the general elements of a trust are the grantor who sets up the trust property, the trustee, and the beneficiaries. So the private trust company would serve the trustee component of those four components. And a very important structure as it is. Most families, 70% of them, in fact, name family members as trustees directly. So since the mid-90s, family trust companies have gained a ton of interest by a lot of families for a lot of different reasons, and it actually puts a LLC wrapper around family trustees who would otherwise be serving individually, and there's a lot of advantages to that wrapper.
Indeed there is. So we're going to jump right into it with probably the most complex question and deep dive that we're going to do, because it's going to require a lot of follow-up. But it's really important to lay this foundation. How is a private trust company, and by the way, also known as a PTC, how is a private trust company generally structured? Let's talk a little bit about entity, board of managers, committees, etc.
Yeah, good question, Angelo. They're usually LLCs, although you do see situations where they could be corporations, depending on the family's other holdings. But generally, they're LLCs. The LLCs are LLCs in the private trust company state. So most of those LLC statutes in the private trust company states are fairly advanced and very good. There's a board of managers obviously named that will run the entity itself. There's officers named. There's an investment committee, which in turn would run the underlying investments of a trust because the private trust company is named as trustee. A distribution committee that would be in charge of distributions. An amendment committee, which is very important with the IRS Notice 2008-63 so that the trust companies are not included in one's estate. The amendment committee deals with the amendment of the governing documents that might affect the committee or the entity. And what the IRS ruling boils down to, because a lot of people say, how can we have a family-owned trust company that serves as trustee for family trust and not cause any estate tax inclusion issues? And the IRS was previously issuing letter rulings. In fact, those were 3 of our clients that got the 3 letter rulings that are the ones that were used prior to the IRS saying we're not going to issue any more letter rulings and put everything on hold until they issued IRS notice 2008-63. But what it basically boils down to is it's no different than if a family has a trust without a private trust company. The basic premise is if there are distributions from the trust and they exceed, they're called tax sensitive, they exceed the family's health, education, maintenance, and support standard, those are considered discretionary and tax sensitive. And they can't be made, the distribution decisions can't be made by a family member. They have to be made by an independent trustee or an independent member of a committee. So with a trust company, the distribution committee needs independence so they can make those distributions, and they also need independent people so they can amend anything in the governing documents that might affect the distribution committee who is making that distribution. And who's considered an independent? Well, basically, it boils down, so it's not a family member, it's not an employee of the trust company or the family office, and it's an independent, not a subordinate under 672C of the Internal Revenue Code. So as long as those parties join the family on the distribution committee and on the amendment committee, usually that's the general premise that gets the whole structure around the any estate tax inclusion.
Excellent. Let's talk a little bit about kind of effectively the ownership entity of the PTC. I'm assuming usually it's probably a specific purpose trust, but if you could describe a little bit and give a little bit of an understanding of exactly what that is and why that's the best entity to own the PTC.
Yeah, you hit the nail on the head, Angelo. The purpose trust is excellent. Some families will look to own the private trust company individually. That's not recommended for asset protection and in some instances, state income tax purposes. Some families may inquire about having a family trust owned with family beneficiaries, have a trust that the private trust company is going to serve as trustee of with family beneficiaries, own the trust company. That's kind of a circular fiduciary conflict, so that's not recommended. To have the private trust company as trustee of a trust with family beneficiaries and then have the family also be working within the private trust company structure. So you hit the nail on the head. The purpose trust is usually where everyone gets. The purpose trust is a trust with the grantor setting it up. Usually you can have an independent person declaring it. The trust property is the private trust company, and the purpose of the trust is to perpetuate the private family trust company in perpetuity, depending on the state. It could be a long-term, it could be perpetual. And there's a trust enforcer to enforce that purpose, and there's a trustee in the purpose trust jurisdiction, which is also usually the private family trust company situs jurisdiction. So it's kind of a neat structure. The key to the purpose trust is it doesn't have beneficiaries. So in a normal trust structure that we mentioned, there's the grantor who sets it up, or the settlor, there's the trust property, there's the trustee, and then there's the beneficiaries. With a purpose trust, there's the settlor who sets it up, there's the trust property, which is the private family trust company, and there's a trust enforcer to enforce the purpose, and then there's a trustee, but there's no beneficiaries. So families like it too, because in any beneficiary agreements that might arise, they're not going to affect the ownership of the private trust company directly, and it's added asset protection to maximize the situs in the private family trust company jurisdiction. So you, as I mentioned, hit the nail on the head. The purpose trust is powerful. A lot of people aren't aware of it, but once they gain familiarity, that's usually the option they'll choose when they weigh the pros and cons of owning it outright or having a normal family estate planning trust own it. It's usually the purpose trust. The advantages outweigh the negatives of the other two.
And if you could remind me, I might have missed it because earlier on you said an LLC. How does the purpose trust that owns the PTC, how does that intertwine with the LLC? Is the LLC simply how the PTC is structured?
The LLC is owned, so the purpose trust is the member, the 100% member of the LLC. So it's the owner of the purpose trust, and the purpose trust is the owner of the private family trust company, and the family would still, it doesn't interfere with their operation of the private family trust company. They would still operate that through their board of managers and officers and investment committee and distribution committee and amendment committee. So all it is a protective wrapper owner of the private family trust company, almost it's not an LLC, it's a trust, but it provides a trust wrapper over that private family trust company LLC.
And because it is a trust, that means there must be a trustee. What is usually going to be the most common trustee? Is it a family member? Is it a corporate entity?
Great question. Of course, usually the private family trust company cannot serve as the trustee initially of the purpose trust because it's in the process of being set up. So another trustee generally has to be named in the interim. And then once the private trust company is formed, they'll resign, and the private family trust company can then serve as trustee of the purpose trust. So that's a great question. Sometimes the family wants to not name the private family trust company as trustee of the purpose trust and leave an independent trustee in the PFT jurisdiction for just that trust. And then the family will use the private family trust company for all their other trust.
I'm thinking more of traditional trust where sometimes the family may want to have, I'm not going to use the word out, but an opportunity if they're not happy with probably more of a corporate trustee to have something called a trust protector. That doesn't appear to be as needed in a PTC given the family's level of engagement and involvement, or where am I wrong on that?
Well, it's another excellent question, Angelo. The trust protector generally would not be present in a private family trust company, you're right. It could be present in a trust that the private family trust company is named as trustee of. And you could also see a trust protector, and it's highly recommended in the purpose trust, because in the purpose trust, you'd have the trust enforcer enforcing the purpose. The trust protector could then deal with any aspects of the trust that might go awry and amend it. Down the road, if the purpose ever ceased, you could turn it into a beneficiary trust, but usually most trust companies are perpetual and set up that way. So the trust protector still has a role, but a lot of times it's not within the private family trust company, although it could be. Most of the time, you could have a protector as a sounding board within the private family trust company, but a lot of times they're built into the trust that the private family trust company would serve as trustee of.
And yes, I know, everyone, we're diving into some pretty deep and hard questions early on, but I think it's important. And for the most part, in some ways, especially if you could see more of a flow chart, it actually isn't that bad. But without the visual of that and talking about it, I realize it could look a little complex. And adding to that complexity, still a bunch of questions related to the initiation and structure. And that would be, Single family offices historically have been incredibly private for obvious reasons. In 2011, the SEC went after that a little bit. There was a compromise relatively favorable to the family in what's known as an exclusion from needing to register as an SFO and kind of become open, for lack of a better word, to prying eyes. So it loses the privacy. But for those that either, for whatever reason, may qualify but want to go in a different direction or don't qualify for that exemption, maybe certain linear family engagement involved in the family office, whatever, they have an alternative route to create a private trust company. Now, it's not like they're avoiding any sort of regulatory compliance, but they probably exchange the federal government and SEC for a state banking authority. And no offense to state banking authorities, it probably is a worthwhile trade-off for many families. If you could discuss a little bit, if not necessarily the exemption, but the fact that a PTC or maybe a regulated, and we'll get to regulated, unregulated shortly, will qualify for the exemption.
Great point, Angelo. The major advantage of a regulated private family trust company versus an unregulated private family trust company is it can qualify for SEC exemption because it's a non-depository bank, and there's a bank exemption to registering with the SEC. So that's a major advantage to many families because, as you know, if they have to do an ADV, the amount of information that is publicly available is enormous, and a lot of families don't want to have that on the internet. It's kind of like the common reporting standard offshore with all the international families having to report, and they're a bit upset about that, and they're coming to the US to set up entities here, although that shouldn't be their sole reason for doing that. But the exemption for the private trust companies can be very powerful because it also allows a family not only the exemption so that they don't have to register, and as Angelo mentioned, the SEC is in turn deferring to the State Division of Banking at their audits, and those vary. So the jury's still out on this, though, because it's fairly new, and the SEC is deferring to regulated trust companies and Division of Banking regulation, but some of the states are more strict than others. So the question is, when the SEC actually starts looking at that, which states will they honor from a regulated standpoint and which will they not, their level of regulation, because there are different things that might be crucial to them. One, some states are not accredited by the state bank supervisors. So if they're not accredited, the question is, will the SEC honor their audit in place of their own? So if they're only doing one a year and not requiring audits, that could be a factor. So all those things come into play when selecting a PFTC jurisdiction, a private family trust company jurisdiction. Somebody wants to be sure that the level of regulation is sufficient so that down the road, the SEC will accept that. Although generally the concept is they will accept a regulated trust company as an exception because they're regulated by a division of banking. The other main advantage a lot of families like is that instead of dealing with family investor partnerships and the 99 investor rule, they can do common trust funds and business trust. And those would allow the family to have all the family trust investments within common trust funds in different types. They could have private equity in one, they could have large cap in one, value in another. They could have a diversified one and just allocate those funds amongst all their family trust. And they could do the same with business trust. Those are not subject to SEC examination. So not only do they get the exception for the SEC coming in and auditing the family office, and they're having to do an ADV by having the private family trust company, they also can take it down at the investment level by setting up common trust funds and business trust, which can be very neat. And a lot of families like those. And a lot of people say common trust funds. I haven't heard of those in ages, because a lot of the big bank trust companies converted theirs to mutual funds. When I was at Citibank, we did that. But a lot of families, they're very unique, and there may be ways to deduct investment fees as well down the road. So that is something that is a key to a lot of families, but very important, and probably the most important reason to have a regulated trust company.
Yes, and very shortly we'll get a little bit to regulated, unregulated, and perhaps some of the advantages potentially of unregulated besides simply cost. But before we do that, I think there is another important topic in laying the foundation, is that most incredibly wealthy families that create a PTC are probably going to have some type of hopefully formally structured single family office. And I don't want to do a deep dive into the lender versus the IRS and some of the tax advantages of that, although they're relatively obvious. We've done enough podcasts on that, although I do think we're actually probably due for a little bit of an update. But on one hand, they have a formally structured management company, SFO and LLC, and whatever it may be for technical purposes, Delaware, South Dakota, Nevada, Alaska, who knows where it may be. They'll have a PTC. And how does that SFO management company intertwine with the PTC to get the potential tax benefits that were outlined in the family and lender versus the IRS one? There probably needs to be intertwining agreements between the SFO management company and the PTC, that the SFO management company is providing certain specific benefits and services. They're theoretically for profit, and they're charging and getting paid for that. Henceforth, that creates the greater potential of the likelihood of sticking a tax deduction. I probably made this more complicated than I needed to, Al, but if you could untangle that and help the audience out, I think that would be great.
Yeah, no, great point again, Angelo. As you know, there was this Knight case that came about some time ago that went to the Supreme Court, and investment fees that were intertwined with trust administration fees, and at one point they were all called trustee fees, were totally deductible prior to the Knight case. And once the Knight case came down and then final regulations came down in May of 2014, trustees were required to unbundle trustee fees, and investment management fees were no longer deductible as part of a trustee fee. They were subject to the 2% AGI floor, which has since been adjusted. So as you know, trade and business expenses were not subject to the 2% AGI floor. And there are some sister structures that can be done with private trust companies in particular. It adds another layer, which is kind of good for this, but still it's not a slam dunk by any means, as you can see with the lender case. But usually the family offices will enter into service agreements with the private family trust company for all types of services other than trust administration. So the tax compliance, investment advisory, investment diversification, investment management, all these types of services are typically service agreements with the family office or with other vendors that the family office deals with or chooses to deal with. So there can be several of those. There's a way to, a lot of people have come up with, and there's some firms that have varying structures. As Angelo mentioned, it depends on the entity, the newco, the partnership, and how the partnership fees flow, how the investment advisory fees flow. But a lot of people maintain that when you add the trust company component to that, it adds a level that wasn't present in the lender case that could provide an income tax deduction for the investment fees that weren't previously allowed in every case, and then limited after the Knight case. So there are some structures, they vary dramatically, but usually it's not just working with the family office and the trust company. It would be setting up one or two more entities to act as sisters to those two, but they'd all be interrelated.
Yes, that's important. So I know we did a really deep dive there in terms of understanding what is a private trust company, the ownership entity, usually again the purpose trust, some of the intertwining of the SFO management company with the private trust company for potential benefits, tax benefits, potential, and how to do that right, and some of the trustee issues involved as well. So we did have to do a deep dive early because I think that is important. And yes, I do realize without flow charts, it's a little harder, but nonetheless, we are trying. You already mentioned it, Al, but I think it's important to bring up, and I think this could vary depending on optionality of various states as well, the key differences between a regulated and an unregulated private trust company.
Yeah, great question, Angelo. This is a major decision for most families. And once they've decided that the private family trust company makes sense for them and they gain awareness, a lot of times people, thanks to your program and people like yourself, bring that awareness to people and they see how advantageous these entities can be. Generally, to start, the net worths, usually a regulated trust company is not set up, somebody usually 100 million and over and usually several $100 million. At that net worth level would a family look to set up a private family trust company. Now they could have a $10,000 trust, but that's usually the net worth level they'll set up a private trust company. There are a lot of much wealthier, but to go below 100 million, you don't usually see it. It's not that it's not required, but the Division of Banking's professionals would kind of say, why don't we do unregulated or some other type of trust structure? With unregulated, it can be 10 to 25 million, usually in that range or higher. So you come way down on the net worth curve. They're both LLCs, whether you do regulated or unregulated. Another key difference is with regulated, it takes 6 to 8 months to set up usually. And with unregulated, it's 3 to 4 weeks. So they're very quick. With regulated, you get a charter. With unregulated, it's generally a license, referred to as a license, depending on the jurisdiction. With audits, as Angelo alluded to earlier, the regulated are audited between 1 and 3 years, usually 3 years in the family trust company arena, so once every 36 months. With unregulated, there's no audits. Now, a lot of people say, oh, wow, that's great. It is great, although I'll tell you, a lot of the division banking audits for families are not overbearing, and it's a good checks and balances. And the problem arises is if there's ever litigation against the family or against the trust company, and if somebody sues a trust, they sue the trust property, usually the trustee and the depending on who's involved in that structure. The key is the more formalities you follow, the better. So even one of the formalities that the Division of Banking promotes is making sure everything is in place so that all the formalities are followed. And the key is with an unregulated, you want to be sure that you're at least following a minimum amount of formalities, which we'll talk about in a minute. The regulated gets SEC exemption, the unregulated does not. The regulated has capital requirements of between $200,000 and $500,000. There's no capital requirements for unregulated, but highly suggested you at least put 10,000 in as capital. That's one of the formalities. It isn't required, but highly suggested. Board meetings with regulated are usually 2 to 4 years, although there's one state trying to get trust business that's silent on it, and one they're not required. If a board meeting isn't required and you have a regulated, I would highly doubt the SEC is going to eventually honor that. So those are the type things you have to look at, even though the regulated generally are SEC exempt. If you have a state statute or a state division of banking that is not auditing, silent on it, those things can be weaknesses. So you've got to be aware of those things. And also, if the state banking auditors are not accredited by the state group. Insurance is very important. Either entity, the underlying board members and committee members can get directors and officers and error and omission insurance. This is another key to both regulated and unregulated, because if families are serving individually, it's hard to get individual fiduciary insurance. And families that aren't in the private family trust company states are subject to a reasonable care standard when they're serving as co-fiduciary, and also high personal liability. When the minute they set up a private family trust company structure, the LLC absorbs the liability. They've got D&O and E&O insurance, and the liability standard is gross negligence, willful misconduct. So you're really protecting the family to act in a fiduciary capacity versus they're just serving as co-trustee in a state like New York or California or some other state with a high liability standard and personal liability. The other major component is a bank account. Usually you need a bank account in a regulated state as a transactional account. A safe deposit box or a fireproof high-end file is required to store the trust records. Unregulated, neither are required, but highly suggested, again, for the formalities. So if there's ever litigation, they can show some of the formalities. The board members, there's a question whether you need to be a resident in a regulated state. Some require, some don't. Again, that's a great factor in favor of the SEC registration to have a board member in the private family trust company state. With unregulated, it doesn't matter, but again, very helpful. So a lot of times if you can get a lawyer, a CPA, there's corporate agent service providers that serve that role. And a lot of people say, I don't want somebody like that on our board to hear family trust matters. Remember, they can be on the board just to deal with the banking and private family trust company issues. And then you can go into executive session for any personal family matters, so they're not hearing them. Due to the level of experience, some people want them also involved, so that's important. You need an office, a physical office space with a regulated trust company in most of the jurisdictions. With an unregulated, you don't, but you need a physical address. So usually you'd hire a corporate agent, like the LLC agent, that could deal with service of process. And those are kind of the major differences between the two, with the SEC exemption, again, being probably the most important. But you don't want to lose sight of the fact that either one of these entities could be sued. So with unregulated, there's probably a base level of formalities that you want to be following. So if there is litigation, you can show that those are being followed so that they won't pierce the corporate veil and say this thing, is not really what it's labeled as, which is an institutional trustee.
I'm assuming to set up a unregulated trust company, because usually it's going to be someone below 100 million anyway. But in general, from what it sounds like, it's probably much, much cheaper to initiate and set up.
Yeah, another good question, Angelo. Yeah, the setup costs for regulated vary between 50 and 100,000, and the setup costs for unregulated, can be between 10 and 25. So, and you can see some north of that. There are some situations that can get out of hand with the setup fees, but you can set up a great entity in that range of fees. The operation fees are the same too, a lot less with unregulated than with regulated, because there's more formalities with regulated than there is with unregulated. But again, the regulated should keep in mind there are certain minimum formalities they should be following. Some unfortunate unregulated trust companies, at least in my eyes, they just they're formed, the license is thrown in a drawer and nobody does anything. And pray to God there's no litigation because that's not the way to deal with them. A lot of families don't want the Division of Banking audit, but they can't prevent lawsuits. So if a lawsuit ever happened, and that's the case, and they're dragged to court as trustee, the first thing the court is going to ask is the formalities of the trust company and the legitimacy. So those are all key things, even with unregulated, not quite as many formalities, but even though they're not required, you want to be doing some of them.
What are some of the key differences between among the most common states where PTCs are created? South Dakota, Wyoming, Nevada, probably being the big three.
Yeah, the regulated states are basically Florida is relatively new, New Hampshire, Nevada, Ohio is new, South Dakota, Tennessee, Wyoming, and Texas. But you're right, on the regulated side, South Dakota, New Hampshire, Nevada, and Wyoming seem to see the bulk of those. And on the unregulated side, Nevada and Wyoming are by far the two most popular for unregulated private trust companies. When you're looking at the jurisdictions, the idea is to first note, do they do both? And secondly, what's their comfort level with both? Some have more comfort level with unregulated than they do with regulated. And then most of them, particularly the experienced states, have a lot of good advisors and corporate agents to help with the setup and the formalities and the coordinating the board meetings and all of those type things from those locations. So and making sure that everything on the regulated side is the I's are crossed, dotted, and the T's are crossed so that the SEC exemption will apply. The other key is most of these states do not have income taxes. When you look at that list, there's a couple exceptions, but most of those states don't have income taxes. So there's ways for a family to structure their trust and get around the income taxes in a lot of instances. In some instances, families could care less about that. There are some situations where you've got the private family trust company and none of the trusts are being administered in the private family trust company state. Now, the question might come, how would you administer a trust in the private family trust company state if all the family employees are in the family residence state? And the way they do that is usually by hiring a trustee agent in the private family trust company state to just do the basic trust administration to justify trust situs. And that is important, but they don't have to do that with regulated, and in some instances, most unregulated, there's reciprocity. So that the family could set up the private family trust company in the private family trust company state and do the administration in their home state. They wouldn't garner any benefits of the trust laws of the private family trust company state, because usually in that instance, they're dealing with trust laws of another state. But that reciprocity exists with regulated and in most instances with unregulated, depending on the situation in the state.
And in terms of, and we covered the subject somewhat, but it really is an anchor one. Perhaps we should have done it a little bit more formally earlier. Generally, what are the key advantages? Why would a very, very wealthy family want to create, let's say, a regulated trust company? I'm assuming it's streamlining operations from a trustee perspective, the capability of getting D&O and E&O. Yes, we could go into the exemptions from registration, all that. But if you had to list them, top 5 or 6, what would they be?
Yeah, another big one is governance, because that exists
Yes.
at the family office level. But what it does is it kind of puts a framework and allows the family to participate in the administration of all the family wealth, because in some instances, the trust own all the family wealth. So the family office deals with that from an investment perspective, from a tax perspective, from a lot of different aspects, but in some instances from a trust perspective. So this private family trust company is a sister entity to it, but really puts really a bow on the framework of the trust administration function. And usually, as we said, 70% of the families will name individual family members as trustee versus institutional trustees, particularly at the family office level. The issue is incapacity, death, or retirement. This LLC entity never dies. It's owned by a purpose trust that is dynastic and never ends. So you've got a perpetual trust administration function, which is very good. There's employment opportunities for the family, great vehicle to promote family values. So a lot of families use the investment in the investment committee to educate young family members on investing, the distribution committee to educate young family members on the family values and the promotion of social and fiscal responsibility. That's extremely important. A lot of times families have had issues with institutional trustees, either turnover or whatever, and the services they found were not tailored enough to them. They were being fit into a cookie cutter. With their private family trust company, they can tailor the services how they want them. They can have control over the transition of the advisors and the employees versus hearing somebody retired and they're being blindsided. They're in control of all that. Now, it doesn't mean they can't hire outside vendors, so they can. But they would all be service agreement and they'd have more control over it, being able to hire and fire than working directly, with the institutional trustee. Another big one, investment flexibility. They can hold one position in a public or private security without any trust law issues or Prudent Investor Act issues in most of the private trust company states, whereas in other states like New York, California, and most other states, you can't do that. You've got to diversify in accordance with the Prudent Investor Act. And the Prudent Investor Act coming in the early 90s was a reason that the private trust company gained popularity. The other thing is a lot of families are nervous serving as co-trustee in a New York or California law trust if there's a very sophisticated asset diversification with foreign assets, direct private equity, art, timberland. They're nervous about that because they can delegate that to somebody, but they can't delegate the risk. They're just delegating the function. So they're still on the line with personal liability. They're much more protected with the private family trust company wrapper and the laws of the private trust company state, and again, with a gross negligence, willful misconduct standard. A lot of families own very illiquid assets, closely held businesses, real estate, oil, gas. They may have hotels with gambling interests. They may have environmental interests. It's very difficult to name institutional trustees. A lot of hotels have gambling interests. Some families own casinos, or they don't realize there's gambling interest in some of their entities. The owner of the entity has to register as a gambling agent. So a lot of trustees aren't comfortable with that. The private family trust company could do that. That's another reason. Deducting investment fees, privacy, and personal liability all add to the list, but those are some of the more important ones we see for the private trust company. So a lot of key things when you add the tax reasons and the liability and asset protection and everything else and the family governance in perpetuity. It's a powerful, I get excited when I talk about it, a powerful offering.
How does a private trust company operate once it's established? And I guess that goes also to the importance of having policy and procedures.
Yeah. The policy and procedures, particularly with regulated, is the most important thing because that is how the trusts are to be administered. Now, you don't want a 4-inch thick policy and procedures manual, but you don't want a 2-page one either. You want one that is acceptable to the auditors, isn't overbearing, and covers everything it needs to, but no more. Because when the auditors come in, as you know, they will look at everything it's in anything that they're supposed to audit. It's a checklist. So you want a very user-friendly policy and procedures manual. Very few families will do those off the shelf. You want them tailored to your family and your family assets and your family structure and your family operation and the service agreements that are being entered into with the particular family office. Because then it's a lot easier for the auditor. Otherwise, you can fall into all sorts of possible issues by just taking something off the shelf that's too basic or that doesn't cover everything it needs to or covers too much. So you hit the nail on the head, Angelo. The policy and procedures manual is crucial. Initially, with regulated, somebody has to be sure they've got the presence, enough nexus for the entity in the private family trust company state. So they may need to work with law firms, corporate agents to get the office, get the safe deposit box. They may require a resident board of director. They may require the bank account, as we mentioned, and they may need to host the board meetings out of the private family trust company state. So usually there are service providers in all the private family trust company states providing those services. The lawyers also can get involved, and they're not that expensive, and it provides all the formalities that are needed. The same thing with trust administration. If somebody wants a private family trust company trust law, wants a trust, say, from one of these states, Wyoming, Nevada, South Dakota, they need it administered there. So they'd have to hire an agent to do the administration, because remember, the family trust company is the trustee. Then the policy and procedures manual is how the trust would be administered. There would be audits, usually once every 36 months. They audit for the policy and procedures manual, but most all the states follow the uniform trust company system for audits, which is MOCA, M-O-E-C-A, and they're looking at management, operations, earnings, compliance, and asset management. So those are the factors they're auditing. Now with family offices, they're not, usually they're all break even, so the earnings is not a big thing, but they will look at management, documentation, policy and procedures, account acceptance, all of that. And it sounds like a lot. This isn't, if it's done and people just get the system down, but there are service providers that have turnkey packages to help families, you know, with these type of things. And lastly, the board meetings. There are a couple regulated states that are silent regarding board meetings, and in one, they're not required. Most have 2 to 4 per year. I'll tell you, I would not go with any less than 2 to 4 per year, particularly if you want the SEC exemption. Same thing with a unregulated, you would at least want 1 a year in an unregulated. You would not need any more than that, but if it was warranted, you'd want obviously more than that. So those are some of the formalities. It's interesting on an unregulated, Angelo, there's not much required other than when they're setting up to state that this is a private family trust company only going to cater to one family and won't be open to the public. So if they state that in their articles of organization, they have a registered agent address and a physical address, they qualify in most states. The key is they probably want to take it beyond that. They want the formalities. Why? Not because they're going to be audited, because they're not going to be, but in the event of litigation, you know, they want to have an annual board of directors meeting, and they probably want it emanating from the private trust company state, at least telephonic. They want a bank account there, a safe deposit box there. It would be good to hire a director there, officer there if they can, and they want a policy and procedures manual that they can follow on the administration of the trust there. So with unregulated, even though it's not audited, they want to be following some formalities. So if the trustee is ever sued, that they can justify there being an institutional trustee versus just in name only.
Indeed. And sometimes I have a couple of quick announcements to make. Won't be as applicable to those that eventually hear this on a podcast because it'll be too late, but you'll hear it on a future podcast. But my live audience listening in, we do have a very special guest on my online meeting and video and audio next week on Friday. That's Friday, May 15th in the afternoon, 2 o'clock Eastern, I believe. We have the one and only Jeremy Grantham, which I'm really excited to make that announcement for those listening in live. It's going to be a very complex and engaging conversation, and I very much look forward to it. If you wanted to send me an email, those listening in, to make sure you get the invite, feel free to do so. Al, can a private trust company act as a trustee for family trust with laws from a different state than where the private trust company's jurisdiction is?
Yeah, I mean, that's a great question, Angelo, and that gets into the interstate and which states recognize which states. Most states will recognize trustees in another jurisdiction to act as trustees for their trust laws in their trust. So, for instance, a New York trustee could be trustee of Ohio Trust or vice versa, because all the states have reciprocity because they want to encourage trustees to be able to deal with administration both ways. A lot of private family trust companies, when they're looking at trust laws, will set them up for two reasons. One, to not only get the benefit of the private family trust company laws of a particular state, but also to take advantage of their dynasty, asset protection, no income tax, privacy, all those type statutes. But in a lot of instances, some families say, we don't care about any of that. We just want our trust administered. So as you mentioned, a popular option is for the private trust company to be set up, rely on the reciprocity statutes, and then administer the trust. Say it's a Wyoming, Nevada, South Dakota trust company, administer the trust in the home state of the client. So that can be done in most instances. There are some exceptions with unregulated, but with unregulated and regulated, that's a frequent occurrence by a lot of families where they say, we don't really care about the beneficial trust laws of those states. We just want to have our trust administered and our own wrapper put around it with all the advantages that we've outlined here today.
And for those viewing in live through Zoom, there is the chat feature. Should you have some questions before we wrap up, I have a couple of more questions for Al. But if you wanted to shoot something over in the chat feature, that would be great. Will a family-owned private trust company trigger any estate tax inclusion issues, and how can this be avoided?
Yeah, that gets back to that earlier statement we made. The whole key to estate tax inclusion is just as whether a family has a trust company or they don't have a trust company, the key is if the trust is making distributions and the distributions are tax sensitive, and the definition of a tax sensitive distribution is really exceeding health, education, maintenance, and support. And that can be different for various families. Sometimes that's a high standard, sometimes it's a low standard. But the minute, if somebody is driving a certain type car and then they go up 4 notches, that could be considered tax sensitive. Or if they want to buy a huge house, that could be considered tax sensitive. And the reason for these tax sensitive rules, the IRS doesn't want the trust to look like a forest where the family's just distributing whatever they want, yet it's out of the estate and they're not following formalities. So there's 2036, 2038, 2041, all these sections that could cause estate tax inclusion if things aren't properly handled. So the safeguard is basically the IRS says any distribution from a trust, we want an independent, not a family member, not a family employee, not a subordinate of the family. We want an independent co-trustee or investment committee member, or distribution committee member to be making that decision and distribution. Now, it could be more than one. It could be 2 or 3 co-trustees or several committee members, just so that there is some, it's not just a free-for-all with distribution, so to speak. So that's at the trust level. At the trust company level, if somebody sets one of those up, it's up a notch, so that the distribution committee, along with the board of managers and the investment committee, needs to have independence for that same reason. So if there are any distributions above health, education, maintenance, and support, that an independent person can make it. And in line with that, the amendment committee of a private family trust company, which deals with all the corporate documents, the concern was they could indirectly affect distributions by dealing with other corporate documents in the LLC. And the IRS wanted to prevent that. So they said you need independence on the amendment committee so that they in turn will be making the same independent decisions, because if you can amend corporate documents, they could indirectly affect the distribution committee. So the IRS, issued the 2008-63, which provides the guidance, and the letter rulings prior to that provided great guidance. So between those 3 letter rulings and that IRS notice, I said river ruling, it's a notice, that's really powerful, and it's easy to get around the estate tax inclusion rules for a private trust company if someone follows all that.
We did have a question come in from the Zoom feature. How can a private trust company be a trustee for an offshore, let's say Cayman's trust, and how does that work?
Yeah, usually a U.S. trustee can serve as trustee of a foreign law trust. It's not recommended. There's a lot of issues. What the trend you see is quite different. You see a lot of foreign trust domesticating through decanting or declaration of a new trust here, and usually the foreign trust has powers to move to the U.S. So you usually, particularly if there's U.S. beneficiaries, but even if there are not, there's a ton of reasons for the foreign trust to domesticate. If it doesn't, you'd have to look at each situation, because there could be accumulated earnings tax issues. There could be a lot of tax and reporting issues depending on the makeup of the family, whether it's purely foreign or there's foreign family members as well as U.S. family members. And it's kind of an interesting trend there, because student visas are being cut back dramatically. And, a lot of those students would come here and they would go to school and they would stay here, raise a family, and then their parents would have foreign trust and look to set up U.S. trust to sister with those foreign trust. And that's still popular, but with fewer students coming here, that's been impacted a bit. But so it would depend on the family situation a bit, but most of the scenarios are domesticating. Families are domesticating foreign trust versus leaving them offshore. But a family trust company could most likely be, you'd have to look at it, but a trustee of a foreign law trust.
Yes, excellent answer, and excellent on basically answering my next question was international non-U.S. families decanting and bringing trust over to the U.S. And you're starting to see, like you did say, more of that with a private trust company. We kind of covered a little bit of that topic several times in the last 2 months or so. And as many challenges as we perceive that we're having, COVID-19 or not, tax issues, the onerous IRS here in the US, and all those kind of negatives, you have to realize, compared to many, many other countries, the stability of the government, power of our military, agriculture, etc., there still is tremendous benefits for a lot of families. Look what's going on in Mexico, Venezuela, and other countries. Trust me, a lot of the billionaires would like to have further operations here, even if there may be a bit of a tax hit. But again, perhaps another discussion for a different time. You've wrote about it, I believe, before, Al, just to show the power of a private trust company and why many quote unquote billionaires have one. Like, what's the ratio or percentage of people on the Forbes 400, or at least US centric Forbes 400, that have a private trust company? It's got to be over 60, 70%.
I mean, I wouldn't say it's that high. It's growing in pop. Remember, it's only been out since the early 90s, so to speak, when the Conference of State Bank Supervisors kind of endorsed the statute, and we implemented it at Citibank with our South Dakota Trust Department, which was state chartered. At that point, some families looked at it. It's gained quite a bit of momentum, but I think families are not only looking at private family trust companies, but they're also looking at all the modern trust structures and not necessarily, some of them realizing they may not need a trust company, but some of the modern directed trust structures are sufficient for them with trust protector companies and special purpose entities. But I will tell you, it is a fast growing phenomenon, but I wouldn't say it's quite that high, number of Forbes. There's a huge group, but it's not only just trust companies, they're emanating to modern trust. Well, when you look at it, the top 1%, back in 1995, only 12.5% of their assets were their gifted assets were in trust. Now it's way over 40.
Wow.
So from 1995 to the current day, it's jumped that much as that awareness has grown. So, and it keeps jumping. I would venture to say it's higher today. So it's still an education process. I think, though, when families find it out and aware of all the options, they can make informed decisions. They're obviously successful people, but, a lot of these vehicles, whether they're a trust company or just a directed trust with some of the supplemental entities, they're powerful for a lot of families and can answer a lot of their needs and provide a lot of tax and asset protection and non-tax benefits. So I think that the total package has grown maybe to that level, but not all trust companies.
You kind of answered what probably is my last question, and not to take the shine off of a private trust company, but I mean, of course, there's alternatives that may be simpler and easier, for lack of a better word, and that relates to what you just said. Are trust protector companies and special purpose entities a good alternative to a private trust company?
A lot of families think so. And what they are, basically, trust protector companies are very popular in Wyoming and Nevada. Special purpose entities are very popular in New Hampshire, Tennessee, and South Dakota. And all they are is, as we mentioned earlier, the private trust company has the board of managers, it has the investment committee, the distribution committee, the amendment committee. Generally, there's maybe other committees, but those are the major ones, and the other committees could be part of the board. But with a directed trust, this is what needs to work with the trust protector company and the special purpose entity. And as you know, with a directed trust, it's a trifurcated trust structure where you have an administrative trustee in the state where the statute is. And then you have an investment committee, distribution committee, and as Angela mentioned earlier, a trust protector. All those three are sitting there and serving individually. The administrative institutional trustee is in one of those states, Nevada, Wyoming, New Hampshire, South Dakota. The family members are serving individually as investment committee, distribution committee, and a trust protector, either committee or individual. With a private trust company, they're wrapped in an LLC that's a private trust company and also trustee. With a trust protector company and a special purpose entity, they're wrapped in an LLC, but they're not a trust company. They have to work with a trust company in order to qualify. So the institutional trustee's function is somewhat limited, but they still can have the LLC wrapper very inexpensively for under $5,000. And they get the D&O insurance, the E&O, they get the governance, everything they want. It's kind of a neat structure. And most of the operating agreements of these companies will say that none of the investment, distribution, or fiduciary decisions are made in the client's home state. They're made in another state, whether it's Florida, some other place. In the US usually, you don't want to go international because that can pose some issues, but just somewhere in the US other than their home state. Same thing with the private trust company if they want to do that, and same thing with the special purpose entities and trust protector companies. The trust protector companies are not recognized by statute. The special purpose entities are. They register with the Division of Banking in a couple of the states, but they're not, so they provide the great formalities. They provide a big nexus to the situs. They provide added asset protection, and they can be advantageous in some instances for income tax planning at the state level, because instead of people serving individually on the investment committee, distribution committee, and as trust protector, they're serving as agents or employees of a trust protector company or a special purpose entity, LLC.
Well, this has been kind of everything you wanted to know about private trust companies, and featuring Al King. We've been very fortunate, Al, to have you on the show, and thank you for your time. For those that would like to learn more about this, about you and your firm, how could they learn more? Website, email, anything you have?
Yeah, I mean, our website, SD Trust, www.sdtrustco.com is there. We've also got a private trust company website, privatefamilytrustcompany.com. So we've got the websites. That would probably be the easiest way to deal with this. On the international side, we also have an international website with 3 languages, so that's available as well. But those would be the easiest. The main website, again, sdtrustco.com.
And Al, is there on the site, is there a contact form or email or info where they could learn more directly?
Yes, there is. info@sdtrustco.com.
Great. And there have been some people in the Zoom feature that said, really intriguing, a little complex to follow. Is there like a PowerPoint or flow chart? I don't have it, but certainly those that reach out to Al or me through Al, I'll forward your information to him if you don't mind. And I'm sure he'll be perhaps happy to share something. Is there any book that you wrote on private trust companies, and why not if you haven't?
No, we're in the process. We've written a ton of chapters in the publication and, Trust and Estates and other publications, but the idea is to pull them all together. They would actually not be a bad book, because there aren't a lot of situs books out there. They get into the trust and the private trust company aspects of things, but it's all piecemeal, and it's still relatively new. As you know, Angelo, so, but there's more and more being done and fine-tuned, but, that's certainly overdue. I agree with you.
Indeed that is. And on that note, everyone, I'm going to give my close. I'm Angelo Robles, host of Angelo Robles' Effective Family Office podcast. And really enjoyable to do these. And by the way, we've been doing a little bit of sister work on our videos. That's on my YouTube channel, and I registered it a long time ago, so it's a great name. It simply is Family Office. So on the Family Office channel, or Family Office on YouTube. This will be a video up in about 3 more days, so we're excited about that. I'm the founder and CEO at Family Office Association, a global membership organization dedicated to single family offices, doing a significant amount of original proprietary content now more than ever during COVID-19, and hosting global programming featuring amazing thinkers and thought leaders. Now with COVID, that's a little bit on hold, but we've been doing a tremendous amount, effectively daily, online video meetings, many of them exclusive for our members only. and some of them converting into podcasting and videos. We also have a communication portal for our families and other new initiatives that we launched during COVID-19, and many of them will continue moving forward. So you could reach out to me. I mentioned on YouTube at Family Office, on Instagram at Family Office Association. I have a Family Office Association company page, which is rather extensive, on LinkedIn. My website is familyoffficeassociation.com, also angelorobles.com, and preferred email, probably angelo@familyoffficeassociation.com. Thank you all for listening in live. Those of you that hear it on a podcast or video, thank you. And our special guest, Al King. Al, thank you for your time.
Thank you very much. Thank you.
Thank you.